This meeting will be held remotely, and we're using Zoom, so please use the virtual background function of Zoom to show the appropriate color, and members and other participants in attendance must attend the meeting remotely in Hong Kong. And if you want to speak, please use the raise hand function. And when your speaking time limit is up, there will be a counter shown on the screen, and it will go off when your time is up. And let me remind members that during the meeting, you must keep the video camera on and show your faces, whereas the microphone will only be switched on upon my instruction. First item, meeting with the administration. Let me remind members that you should take note of the declaration requirement under Rule 83A of the Rules of Procedure. That is, if you have direct or indirect pecuniary interest in relation to the items being discussed at the Bills Committee, please disclose the nature of the interest before you speak. So let me first ask members whether we need to invite public views on the bill. Just Lo Wei Kwok. Chairman, we are in midst of an epidemic. I don't think it is appropriate to hold a public hearing. Instead, I think we can invite written submissions to be made. Mr. Michael Tian. Mr. Michael Tian, I see you've raised your hand. All right, you've put down your hand. I see that now. Well, I agree that since we're unable to hold a public hearing, we should invite written submissions instead. And we do hope, I think, that the bill can be dealt with expeditiously, whether it is passed or not. So right after this meeting, I will ask the Secretariat to issue an invitation for the public to express views on the bill in writing. So subject to any objection from members, once and if any written submission is received, it will be forwarded to members as well as the administration for a consolidated response. Let me welcome the administration to our meeting. In order to facilitate the conduct of the meeting, I will now ask my staff to clear all the hands raised via Zoom now. Members, if you'd like to speak, please press the raise hand button in Zoom now, and you'll be invited to speak. I will first invite the administration to give an opening. Yes, Mr. Chuck, Chairman, members of the Bills Committee, electoral members. If I may, I'll take about 10 minutes to brief members on the legislative intent of the bill and the content. The outbreak of the fifth wave of the COVID-19 epidemic have dealt a severe blow to different sectors and individuals. Many enterprises, in particular, small and medium enterprises, and those sectors subject to the social distancing measures have been given a shocking impact. In order to prevent large-scale business closures, which could set off a domino effect affecting SMEs and costing jobs, the Financial Secretary announced in the 2022-23 budget that the legislative proposal will be taken forward to introduce a rental enforcement moratorium to prohibit landlords from terminating the tenancy or taking other legal actions against tenants of specified sectors for failing to settle the rent on a schedule. This provides a breathing space for tenants of specified sectors in trouble. so that they would not be forced out of business by legal or other actions taken for the repayment default, while tenants and landlords can work out the mutually agreeable rental arrangements meanwhile. This legislation will not take away the right of landlords to receive or the obligation of tenants to pay rent. It will only cause a slight deferral of certain actions that the landlords may take in respect of the tenant's failure to pay rent. Since the announcement, we have held a number of consultation sessions to seek views from the relevant stakeholders, including the READER and the Hong Kong Association of Banks, and about 20 trade associations and some 30 Legislative Council members. At the Finance Committee on the 24th of February, we also listened to views expressed by members on the legislative proposal. Based on the views expressed by stakeholders, we have made certain improvements to the original proposal. First, the protection period originally will last for 3 months plus 3 months. Now it will only last for 3 months to enhance certainty of the proposal. Second, landlords or lenders, being banks, will also be barred from taking actions in relation to landlord borrowers' failure to make repayments. This is to allay the concern of landlords. Third, we're going to introduce another provision. During the protection period, if a new rental agreement can be reached between landlords and tenants through negotiation, the moratorium will be carved out. The application of the moratorium will be carved out. This could help landlords receive payment and minimize the possible losses incurred after the protection period. Both in relation to 100% personal loan guarantee scheme. Under the scheme, the government will provide an interest-free loan equivalent to 3 months rent, subject to a ceiling of $100,000. That's for landlords who lives off rental income from the specified business premises. And the payments of rates and government rents will be deferred, free of surcharge and interest. The government also consulted the relevant electrical panel in March. Basically, we have members in principle, support in principle. There are the following major provisions relating to this bill. Clause 1 sets out the short title. Clause 2 defines expressions used in the bill, including the definition of protection period, which is the 3-month period from the beginning of the commencement date of the bill. Clause 4 provides that once a written agreement is entered into during the protection period, then the bill ceases to apply. And the same goes for a loan agreement or secured loan. Clause 5 provides that the landlord will be prohibited from taking actions such as terminating the tenancy or suspending the provision of utility services, deducting from the deposit, and also the terminating the tenancy, recovering interest surcharge on the rent, bringing an action in a court, including dunning the rent in arrears starting from the 1st of January, commencing any arbitral proceedings, presenting bankruptcy petition, and applying for distress order, etc. As for legal proceedings to dun the rent in arrears since the 1st of January 2022, the actions will have to be deferred even though they have been initiated. Otherwise, a penalty of twice the amount of the rent claimed, and in any event, not less than $50,000 on a landlord may be imposed. The same applied to the lender of a secured loan. Clause 7 provides for the obligations or the rights for landlord to take action against repayment default. Clause 7 provides a similar scenario for the lender against the landlord borrower. Clause 9 empowers the financial secretary to amend the schedule. For the types of premises in Part 2 of the schedule, there are 17 of them, including the scheduled premises under Cap 599F, catering businesses, and 15 other types of premises. Basically, these are premises in sectors that obtained support under the 5th round of the anti-epidemic fund, and also premises in which hobby classes are held. And if the bill is passed, we propose to submit a notice of resumption of second reading on the 8th of April for resumption of second reading and the third reading of the bill. My team and myself will be happy to take questions from members. Thank you, Mr. Chair. Okay, let me read out members who have indicated their wish to speak. Mr. Xiu Ka-fai, Mr. Chan Chen-ying, Kwok Wai-keung, Chen Xiu-hong, Duncan Chiu, Kenneth Fogg, Doreen Kuhn, Chow Man Kwong, Long Han Bill, Michael Tin, Eunice Yong, Lo Wai Kwok. Each will be given 5 minutes. We start with Mr. Peter Xiu. Thank you. Now, the government wishes to introduce this bill to support affected businesses. We're grateful because we are in dire straits, and without government support, I believe that many tenants of business premises would be forced to close down in a short period of time. Well, of course, if you don't subsidize landlords, they will be affected as well. In the past 2 years, I understand that landlords have been reducing rent by 30%. And sometimes reduction is based on the turnover received. And according to some developers, they even waived rent if you're forced to close because of the epidemic. And I'm grateful to them. But the point is, not all developers provide the same level of support in this wave. So by introducing this bill, we're able to provide full support to all those sectors affected. So for affected business tenants, I understand that there is a way out, and that is to negotiate with the landlord. And if you can come up with a mutually agreeable rental agreement, then you can carve out the application of the moratorium. So, Mr. Chuck, is it that the agreement should be submitted to the government for record? Mr. Chuck? We have not required the submission of such agreements for our keeping. It is similar to the signing of any tenancy or agreement, be it a tenancy or otherwise. There is no need to submit the agreement to us. Now, as long as you have come up with a mutually agreeable arrangement, you'll be carved out of the application of the moratorium. It's pointless to submit that to us for keeping, because in the case of any dispute arising from the arrangement, the new agreement can be used as a corroborative evidence. There is no need, therefore, to submit the agreement to us. But of course, it should be set out in black and white. It should not be a verbal agreement. Am I right?
And the bill said it's written agreement. Well, for this written agreement, that in case of any future dispute or if it goes to court, that it can be used to be proved. Understood. Second question, and for the banks, I noticed some of the landlords For the past 2 years, the rateable values of the properties have much reduced, and some of the landlords rely on the rent to make repayment to their mortgages. And this bill mentions, in case for this affected landlord, they could be exempted from lenders taking action. Mr. Chair, as I have introduced bill to forbid the landlord or borrower that would, in case of a repayment default to the bank, this is enshrined in this bill. If the landlord would take action, then there will be a breach of this law. And if you look at the bill, there are 16 types of actions. Most, if not all of them, are legal actions with an evidence trail. If this happens, then the landlord lender can complain to the monetary authority, and the HMA will look at the case. If necessary, it will refer to the Department of Justice to take the appropriate action. Next, Mr. Ronald Chan. Thank you, Chairman. I did declare that I work as a consultant to the bank. The purpose of this bill is clear: is to help the commercial tenants to address the short-term shortage, to let them take a breather. If the economy recovery at the end of the protection period, that can save their business and their employees' jobs. May I point out that the rent agreement entered between landlord and the tenant, as well as the mortgage contract between the banks and the landlord, is a voluntary civil contract. Upon agreement, they are protected by the law and they are contractually bound. Any changes to the contract should be subject to mutual negotiation or ruled by the court. And when the tenant is in arrears, the government decided to legislate against the landlord and the banks to exercise the rights stipulated in the contract. Fortunately, the financial secretary made some amendments upon public consultation. However, this has inevitably violated the principles of the contract, as well as the legal basis for leasing and mortgages. Therefore, this is a one-off measure for the SMEs. It will not be invoked casually from now on. However, I noticed with the administration introduction, this bill disproportionately listed out the type of actions against the bank. This short-term measure, as we all know, that the banks will need to agree when the property is leased to other tenants. If the banks can exercise its right within the contract, this has no impact on the tenants. The administrative means by having the HMA to issue the guidelines to the banks in case of the landlord in default, they should be given a discretionary approach. Clause 7 and 8, I don't see it as necessary to take a legislative approach. 3 months is quite short. I hope that this 3 months protection period can allow the economy to restart. A few questions. For all this kind of civil contracts, this will override all these civil contracts. If the banks purely issue a demand for payment to the landlords instead of taking action, would they be in breach of this bill? By forbidding the banks to take such legal action, which is the enforcement department? According to Mr. Check, Only when someone makes a complaint, then the HMA shall refer to the DOJ. If there's no complaints, who will be the enforcement agency? Within protection periods, will the courts dismiss all this kind of civil lawsuits arising from civil contracts? First, as for the bill, as any overriding powers, besides stipulated in clause 4, or when or any documents related to the lease contain other kind of clauses, or as Mr. Chen is concerned, or violation of any security agreement, or any loan agreement, or any kind of documents, and covered by other kind of provisions, then this bill cannot be applicable. That means that it has overriding powers. And second, simply issuing a letter in breach of this. Issuing a letter or issuing a demand note. In bracket, in clause 5, is on the action expressly forbidden. And for the enforcement agency, if there are no complaints, will the government proactively take enforcement actions? Well, in terms of enforcement, as we all know, let's say, as for the types of tenants covered, expect there will be tens of thousands. Therefore, it's hard to proactively ask the landlord or the lender is in breach of this law. Therefore, we will only act on complaints. So which will be the enforcement agency or to agency to follow up? If the landlord is accused of breaching the law, the ratings and evaluation department will follow up. If it's related to the lenders, then they'll be followed by the HKMA. Thank you. Next, Mr. Kwok Wai Kang. This rental payment moratorium should be a benefit to the SME. The FTU can not support this bill. The major principle is that the SMEs and the workers are interdependent. We allow the SMEs to stay for more 3 months, then the workers should have 3 more months of pay. If the company closed down, our people will be unemployed. Therefore, we'll support this. And about 2 years ago, in 2020, at the start of the pandemic, I proactively lobbied the real estate developers for a 70% rent reduction for 6 months. I managed to meet some of them, while some claim to only deal with individual basis. This bill is quite clear. If you want to enter a new rental agreement, then you will be exempted from this bill or ordinance. Well, I hope that it will empower the SMEs in their negotiation with the landlords. By shortening the protection period from 6 months to 3, well, the government proposes amendment to address the landlord's concerns. Well, this watered down the effectiveness of this policy objective. However, since it's still a benefit of SMEs, I hope it can be passed as soon as possible. One question for the administration, though. Currently, the pandemic is still raging and lots of premises are still closed. The catering establishments are still hit severely. Have we considered or looking at outside overseas experience at the end of the protection period? If the landlord launching a large-scale rent recovery actions, would it instantly lead to wave of closures and wave of layoffs. And what contingency measures do you have in place? If you don't want these layoffs or closures to happen, we're looking at those experience at the end of the protection period, you will request the tenants to pay some of the rent and extend the protection period or other alternative arrangements so that the tenants can continue to operate in order to repay their rent. Just now, we mentioned that since we need some time to make up for the loss during the pandemic, will you reconsider the arrangements so that the SMEs, if they survive this wave, can pay the defaulted rent in phases? Mr. Chair? And clause 4 of this bill exactly will create the effect that allow the landlords and the tenants that during the protection period on how they adjust the rent and how the payment could be made. We hope that this negotiation can extend past the protection period. Well, both sides will need to come to agreement on the number of installments to repay the owned rent. I've heard that some of the landlords that due to this clause, they are more willing to negotiate with the tenants. They said that the key that they were able to collect rent continuously while reducing the rent. That upon the expiration of the protection period, the landlord would have a less chance of the tenant not paying rent. I hope that both sides are more understanding and pragmatic, so that the tenants continue to operate and the landlord will not have their properties vacant.
Any follow-up? Mr. Kwok Wai Keung? Mr. Chair only answered part of my question. My question is, will you consider after ending the protection period that other forms of protection be offered to ensure amicable relationship between landlords and tenants? Now, there are other ways. For example, we enhance liquidity support for them, and we also have personal loan guarantee, other repayment programs such as the pre-approved payment moratorium or pre-approved principal payment holiday scheme. So we have a whole set of packages or a package of measures to relieve their financial burden and at the same time make sure they remain liquid. Next, Mr. Chan Xiu Hong. Thank you, Chairman. The Financial Secretary is adopting an innovative approach in addressing this issue, and after putting forward the rental enforcement moratorium, he has been active in seeking views from different stakeholders in different sectors of the economy to make sure that balance can be struck between helping business tenants and protecting the rights of landlords. I think this is commendable. I think that in terms of the community's response, the rental enforcement moratorium will have far-reaching implications in our economy. This is a breach of the free market principle. And for SME business tenants, there is a question whether it has limited effect. And I don't think you will achieve the result you decide. And when the epidemic gradually subsides in April, by the end of April, we'll be able to relax social distancing measures. And at the same time, the consumption voucher scheme will be rolled out to keep businesses afloat. But since the start of the fifth wave of the epidemic, there are still SMEs and businesses not yet forced to close down, but they are struggling. They're in dire straits. Chairman, so my question is this. I'd like to ask the administration whether you have any cost benefit analysis of the rental enforcement mechanism. I'd like to have figures, data, so that we can assess the effectiveness of this legislative proposal. That is, how many businesses are you going to save from closing down? Otherwise, this is, after all, a major move in breach of free market principles. Yet you may not be able to achieve the effectiveness you desired. Let me first address the issue of a free market principle. The member mentioned this point a number of times, and on different occasions, we met with different members, and we've received inquiries such as these. In fact, there are similar measures in the UK and Singapore, and I want to bring out this point. In the UK and Singapore, they also adopt the common law system, and they implemented the moratorium in 2020. And from what we learned, their governments were not heavily criticized for breaching the free market principle or interfering with the free market operations. As to whether the rental enforcement moratorium is effective, the crux of the bill is that business tenants are spared and that they'll be allowed to pay rent a little bit later. But there are a lot of benefits to be reaped, and landlords as a result would be happy to reduce rent, and this is one way of market corrections. So it's not just about delaying the payment of 3 months rent. Through this bill, we'd like to encourage new rental agreements to be entered into. Now, about the assessment that we've made, because this bill applies to specified premises. And well, by specified premises, I mean businesses benefiting from the relief measures under anti-epidemic fund and basically the retail industry. For the former, we're talking about some 70,000 businesses, and for the latter category, 50,000. Over 100,000 tenants, therefore, are covered. How many businesses, if you ask, can actually benefit from this protection measure? then I'm afraid we don't have the time. We didn't have the time because this is rather urgent. We didn't have the time to conduct a large-scale survey. The message that we've received from the sectors we consulted that is that after floating this proposal, indeed, there have been more negotiations between landlords and tenants. Next, Mr. Duncan Chiu. Thank you, Chairman. Let me declare that my company also runs entertainment and catering businesses. The IT sector welcomes the rental enforcement moratorium when we're grateful to the Financial Secretary for floating this proposal to relieve our pressure. We have service providers of hardware and software, and they're also in dire straits and heavily impacted by the COVID epidemic. So at the moment, we welcome this proposal. My sector has asked me to ask the government to consider the arrangements post-COVID. This is, after all, just a rental enforcement moratorium. Even when the epidemic subsides, it will take some time before all sectors fully recover. And the business outlook at the moment is pessimistic, and landlords usually hold 3 months deposit and there is little room for reduction of rents. So we originally thought that if we had a 3 month plus 3 month arrangement, there would be more room for negotiation. Now it's cut short to just 3 months. At the moment, we're concerned about a possible 6th wave emerging. So let's say between May, June, July, if there are circumstances under which measures have to be put in place for businesses to suspend their operation, can we include this option of 3+3 in the bill so that we don't need to spend so much time discussing the policy and the bill again? Mr. Chair. Let me take your question on 3+3 months. The original package announced in the Financial Secretary's budget is that if need be, the 3-month protection period can be extended by another 3 months. But subsequently, having consulted stakeholders, we understood that many landlords were concerned. For barring landlords from taking action for a repayment default, we're talking about 3 months from the date of commencement, from the 1st of January. This is a reference to the start of the 5th wave of the epidemic. The 5th wave emerged very rapidly, and it raged on, dealing a great blow to certain sectors. So in light of the dire situation, let's say if the bill is passed, so that the bill takes effect in end April and May, then the bill will be in effect between May and August, more than 3 months, in other words. If we keep the 3+3 option, it will cause landlords grave concerns. Now, when business tenants are struggling and barely hanging on at a loss, there may be more repayment default cases to come. So we believe the 3-month protection period is the most appropriate. Next, Mr. Kenneth Fogg. Thank you, Chairman. Let me declare that my company also leases premises to business tenants. In times of an emergency, the Financial Secretary is very bold and innovative. He is trying to invoke an administrative measure to help SMEs. So I'm going to support this bill. In reality, however, what happens to my sector is that, well, we have 70% of practitioners being SMEs in our sector. We have fitness centers, so on and so forth. And according to my sector, their cash flow will dry up by March or April. And I've received a lot of cases requiring assistance. And in fact, many landlords are already dunning not only rent, but also interest. So this moratorium is a bittersweet measure. But in 2 or 3 months, our businesses will have to catch up and make sure they are afloat. It's not an easy task. Mr. Kwok Wai Keung just now made this point, and once again, I would like the government to reconsider. The protection period in the bill is such that the option of a 3-month extension has now been removed. I hope the government would consider introducing administrative measures. There should be concrete guidelines, for example, on assisting landlords in negotiating with tenants on repayment proposals, and guidelines for banks to allow for principal moratorium. Because for SMEs and micro establishments, they are in a disadvantaged position. By the end of April, many businesses will be forced to close down, and this is clearly in breach of the original intent of the bill. Subletting in our sector is also a common scene. For premises for multiple purposes, will they be covered? For specified premises in clause 2 or the specified premises in clause 5, will they apply? Let's say a tenant has subletted part of the premises to a subtenant to use it as a dance studio. Does it mean that the major tenant will not be able to done the repayment from the subtenant? Another point that's mentioned by other members, I'd like to talk about the 3-month protection period. I don't think many people in my sector understand this 3-month protection period. Mr. Chak already gave an explanation. So I also appeal to the government to keep the 3-month extension option, because after all, my sector has been suspended for many months and we've been deprived of income. Mr. Chak, let me explain once again that this is a protection measure. The purpose is to ensure that we can keep the economy going. As I mentioned just now, there are other measures. In fact, in the budget, at the same time, the Financial Secretary announced that there are several measures under the SFGS. For example, we have the special 100% loan guarantee under the SFGS, along with the 80%, 90%, and supposedly the 100% scheme is to be expired this year, but it will be extended to the end of June next year. So SMEs will be able to obtain support under the scheme. As for the special 100 loan guarantee under SFGS, the maximum loan amount per enterprise will increase from the total amount of employees' wages and rents for 18 months to 27 months, and the loan ceiling will be raised from $6 to $9 million, and the maximum period for repayment will increase from 8 to 10 years. Well, I understand that.
So what will happen to these subletters? Well, the subletters are covered in this bill, and in the definition section, that the renters also include as subletters. So whether there are any concrete proposals on the prepayment period during the protection period? That in negotiating with new rental arrangement, we should mention or cover how do we make up for the rent in arrears during the protection period and the level of rent reduction and so on. It's hard for the government to issue a guidelines as well how on the length of the repayment period. And the banks are quite experienced in helping their clients to reorganize their repayment schedule. Well, the banks are quite familiar in handling this kind of arrangements. Next, Ms. Doreen Kong. Thank you, Chairman. First, I would need to declare that I own some commercial property and leased it to the tenants of these specified premises, and my law firm also act on behalf of commercial landlords. As Chairman, I would like to ask Mr. Chuck on some general policy issues. If I have a second round, I would like to talk about the specific clauses. Since the FS announced the framework of this measure, I received a lot of tenants and landlords and inquiries. First, I would like to ask Mr. Chuck, just follow on Mr. Chan Siu Hung's question. Mr. Chan asked that whether do you have any data available. In Mr. Chuck's reply, he only talked about the number of shops affected, but failed to talk about the actual rental income. We all know business is tough. At the same time, the landlord, especially the small landlords, are in a difficult position as well. May I ask Mr. Chuck, has the government studied or retrieved precise data on the actual amount of rent in arrears in commercial property? To enact such a legislation, we simply cannot use the COVID as a pretext. There must be objective survey methodology. I disagreed with Mr. Chuck. It's hard to obtain this data. According to other countries, when they decided to introduce this legislation, they do have strong data proof on the level and extent of rent and arrears. According to the major surveyor firms report, the biggest problem facing Hong Kong is a lot of the tenants, no matter whether the rent is reduced, they simply could not carry on. In a lot of places, they are called zombie occupiers. There's no way for them to survive anyway. Did the government consider that how many of those are not able to repay their rent regardless? If the overall default level is low, then the government should not need to introduce this groundbreaking legislation. If the default is at historic high, then the tenants, as suggested by other legislators, able to make good to all the back payment. At the end of the day, only the landlord will pick up the tab. Well, Chairman, there are some views of the community that the government is simply acting on others' generosity. And for Mr. Check, according to his remarks, he frequently mentioned that a lot of landlords and the tenants have came up with some rental reduction agreement. According to clause 4A, that if during the protection period, if they come up with a new rental agreement, then they will be exempted from their protection. And any agreement reached before the protection period in terms of rent reduction, then the tenants are still protected under this law. Mr. Cheng needs to be careful. I'm worried that a lot of the tenants will mistaken if they actually come up with an agreement before this law be enacted, then the protection period can still apply to them. I hope that Mr. Cheng can reply. Well, Ms. Kong, you're asking about the earlier figures, and Mr. Cheng has provided them. Mr. Cheng, and you can offer a brief reply on this. I suppose that we cannot do the math. Well, from the date of the FS announcement on 23rd of February till this day on 1st of April, we're operating within a short time frame. And deciding to introduce this measure, we didn't have a lot of time. As for whether we need to provide more objective data to convince legislators, this is quite challenging for us. Well, the survey would take a long time to complete. If we need a lot of numerical backup, if we go to Causeway Bay or Mongkok or Canton Road, you know that a lot of the shops are vacant. Should we insist on an objective and exhaustive survey before coming with a conclusion? This is not easy for us. Just now, Mr. Rin Kong said, after 3 months, how can the tenant repay all the rent in arrears? Well, does that mean that on the 4th month that the tenant are required to pay to 4 months worth of rent? That's just a presumption. Well, by common sense, that both sides negotiate how do we come up with a repayment schedule. Well, a lot of companies not need to use this protection period to come up with their own repayment agreement. Well, this doesn't mean that it's just a very short-term relief and lapsed at expiry. We have considered that what happened before the protection period. How far should we act in retrospect? A year or a month? Well, we don't want to leave any room that before the enactment of this bill, in which the tenants were placed under duress to sign unreasonable agreement. Let's say if you extend the lease for 5 more years and so on. Let's say within January to April this year, we reached an agreement, and you claim that this only the agreement reached before the protection period is valid. Well, between the landlord and the tenants, if they are in good relations, both sides will just need to confirm the new rental agreement in writing, then they will satisfy the prerequisite of clause 4, and thus this ordinance or bill will not apply to those lease agreements. Dr. Chairman Kong? Well, during the 5th wave, the landlords, the enterprise, and the staff, none of them are winners. In this precarious economic environment, I think this legislative proposal is inevitable. It's aimed to provide breathing space for the enterprises. Therefore, I support this legislative proposal. The latest proposal offers more flexibility than the original position by limiting the protection period in 3 months. And after reaching the agreement between the landlords and the tenants, and this bill would not apply to them. Well, this hopefully can safeguard enterprises and jobs, and also in the interest of the public. We can't deny that some of the landlords are worried whether this rental enforcement moratorium will create another financial black hole. Look in other countries like the US, UK, and Singapore. Their moratorium lasted for 3 months to 15 months. The latest proposal is just 3 months. It's quite conservative with major concessions. The proposal now ruled out any extension. This will prevent scenarios of abuse. And it would not create a snowball effect. I suppose this achieved a balance and a superior proposal over the original one. However, we need to make references to the jurisdiction, like France, who enacted similar legislations. The government can look into how to streamline the vetting and administrative procedures. Since this bill only effective for 3 months, we shouldn't create any extra hurdles, and we need to boost its efficiency as well. The government should take note of 2 points, and should also need to respond to sector and public concerns. First, a lot of the tenants see their interests as compromised, and this will also affect the Hong Kong's reputation in preserving this contract sanctity and private property protection. How can the government respond? For example, the risk of judicial review. Like other members, I'm also concerned that with the fifth wave lasting into so many months, would it be hovering as existing level? We see that as quite likely in terms of the pandemic's conservative management. In such poor operating conditions persisting, must the government come up with a backup plan so that in terms of the loan guarantee, they can come with a proposal on protecting the public over interest instead of creating more lenders and debtor disputes? Thank you, Chairman. Mr. Chair, can you answer the first question? Well, the first question has been asked many times and the government explained many times as well. Just offer a quick response there. Just a quick one, Chairman. So any risk of judicial review? As we all know, Basic Law Article 105 states about the protection of private property. When we come up with this legislation, at the very early stage, we have considered whether it is in compliance with the basic law. For the very basic right, like the right to private property, if it is to be affected, it should pass the proportionality tests. We have assessed it internally. Well, we can't explain in this meeting as it's a very long process. I reiterate that this legislative proposal does not deprive the right of private property. It's just a slight delay for the landlord to recover their rents from the tenants in the affected industries, let's say for a period of 3 months in which they could not take any legal action. At the expiry of the protection period, the tenants have a duty to repay the defaulted rents. So whether we have any backup plan for the tenants, besides helping them for delayed rent payment, they could also apply it to the various financial scheme to boost your liquidity. Next, Mr. Lewis Long.
Yes, thank you, Chairman. Let me first declare that I am a Secretary General of READER. I want to say in principle, I am against interference with a private contract by legislation because this clearly goes against the free market principle and the right to private property as protected under the basic law. But anyway, since we are discussing this bill, I will, for the moment, set aside my differences and comment on the legislative intent. In paragraph 4 of the legislative brief, I quote, as rental payment constitutes a substantial part of the operating expenses, the budget announces to impose a moratorium, end of quote. So clearly, the purpose of the bill is to provide relief and protection to SMEs, not all business tenants. In the bill, and now all business tenants are covered, and this is far too wide. There are also major commercial tenants not affected by the epidemic at all. And this far goes beyond the legislative intent of the bill. I therefore think that we should amend the bill so as to include a definition of SMEs. Second point, as the administration wishes to provide temporary protection in light of the fifth wave of the epidemic, then the bill should only be effective for 3 months. However, the bill is drafted as such that the relevant measure should commence on the 1st of January this year. And this again goes against the lack of retroactive effect of the legislation in Hong Kong. I'm referring to the reply from the Legislative Secretariat on the 31st of March, paragraph 4. If the bill is passed, the bill will only take effect on from the commencement date of the bill and not earlier. I think it's a matter of rhetoric. Although the bill only has a 3-month effect, it has, however, a retroactive effect as well, starting from the 1st of January. That is why I am proposing an amendment so as to limit the effective period of the bill to 3 months starting from the effective date of the bill. I'd like these questions addressed, please. Mr. Chuck. Yes, Mr. Leung just referred to paragraph 4 of legislative brief. However, may I also refer him to paragraphs 2 and 3 of the paper? And I quote, the outbreak of the fifth wave of the COVID-19 epidemic have dealt a severe blow to different sectors and individuals. It took place around the Chinese New Year with an unprecedented severity and magnitude, considerably dampening consumption in traditionally peak season, causing impact to many sectors. And then many enterprises, in particular small and medium enterprises, bracket SMEs, face huge difficulties, so on and so forth. So clearly, we're not only referring to SMEs, but many other enterprises. And then in paragraph 3, at this critical juncture of the fight against the epidemic, we must take all necessary measures to preserve the vitality of the economy. In particular, we must act to prevent large-scale business closures, which could set off a domino effect affecting many SMEs. And apparently, our goal is to prevent large-scale business closures, which could set off a domino effect affecting many SMEs. So the intent of this bill is not to protect SMEs only, but other businesses. Of course, SMEs account for 98% of all enterprises in Hong Kong. Referring to another point, to commence on the 1st of January, and whether there is retroactive activity of the bill. We actually looked into this issue with the Department of Justice, and the answer is in the negative. Let me put it this way, or perhaps the DOJ representative can supplement. When it comes to retroactive effect, Mr. Long just commented that is kind of a rhetoric, because the bill takes effect on a certain date and then it applies to what happens before the commencement of the bill. There is a difference, however. For retroactivity, we're not talking about the commencement of the bill, but rather that it will be effective before the commencement of the bill. Say, if something is prohibited on the 1st of January, then with retroactivity, such prohibited acts will be prohibited even before that date. But now the bill is drafted so as to read it takes effect on the 1st of January. That is not a kind of retroactivity. Nevertheless, even if some believes that this bill carries retroactive effect, although Mr. Long comments that it doesn't exist in the common law system, there is such legislation in the laws of Hong Kong. And the Hong Kong SAR government has adopted different measures to justify the retroactivity. If the measure only takes effect on the day when the bill is gazetted, then some business tenants would be forced to close down because of the legal actions taken by landlords. A few days after the Financial Secretary announced this initiative in the budget, we read from media reporting that some major property developers had filed over 70 claims for repayment default. And for 11 of these claims for damages, the amount claimed were more than 2 to 7 times the normal level, and that is reality. And now let me turn to overseas experience. Taking Singapore as an example, that piece of legislation only serves as reference, of course. We can't just copy their legislation. We have to have regard to the local circumstances and draw up measures suitable for our own local circumstances. In Singapore, they have COVID-19 Temporary Measures Act 2020, starting to take effect on 20th of April 2020. Certain acts of landlords would be prohibited in the act starting the 1st of January. For Coronavirus Act 2020 of the UK, similarly, landlords are barred from exercising their rights to, say, take possession of the property or repossess the property. And the act applies to situations arisen before the act is enacted. So on this point of retroactivity, this is not unique in Hong Kong. I hope I've addressed Mr. Long's two issues. Next, Mr. Michael Tian. Thank you, Chairman. When this moratorium was first announced, I thought it would be futile because it wouldn't help SMEs. All along, I think the government should provide an incentive for landlords to negotiate with tenants whether there is room for rent reduction. The incentive has been provided by the government. Through this bill, landlords will be willing to cut rent, and this is the right way out. In February, landlords were still quite reluctant, but recently, as I've heard, landlords have taken the initiative to cut rent by half. And then landlord borrowers will not be subject to banks' legal action because of inability to repay mortgage. And there is also the personal loan guarantee scheme, and one can apply for interest-free loan equivalent to 3 months rent subject to a ceiling of $100,000. So it's a win-win for everybody. It's rather watertight, and I support in principle this bill. And once again, I want to commend the government for heeding our views in providing an incentive for rent reduction. No response needed. You don't need a reply from the government. Thank you. Next, Mr. Holden Chow. Thank you. I support this bill. I hope that through this bill, we'll be able to tide SMEs over in these dire times. So I support the bill, and I have a question on clause 4. Of course, we can wait for the clause by clause scrutiny, but as a matter of general principle, let me just say this. Say if an agreement can be reached between the landlord and the tenant to say reduce rent, you can carve out the application of the moratorium. So to quote from the paper, it is said that you can take a step back, and yet there is no specific mentioning of by how much the rent should be reduced. Let's say if the landlord has bargaining power, then this so-called forbearance may come in a very meager amount, and yet you can carve out the application. So may I know the extent of forbearance you're referring to before you can carve out the application of the moratorium? Now, according to SMEs, of course, the moratorium offers some relief, but it won't be easy for them to catch up with the businesses. So I think you should come up with arrangements post-epidemic. I think other members already asked a second question. That is, when the protection period expires, what are the further measures, Mr. Chuck? Second point. I think we've answered this question before. Now, Mr. Chow said that the word forbearance may be a bit vague. And let's say if the landlord has much clout and or bargaining power, well, this is something we have considered actually. We need, well, let's say if we have a very low threshold, 50%, then to put it bluntly, you are eating into the landlord's interest.
If we set the bar too low, let's say reducing the rent by 20%, from the feedback we received in the past 3 weeks, some landlords decided to cut the rent in half and some by 30%. It very much depends on the value of the property and the style of the landlords and the affordability of the tenants. It's hard for the government to come up with a single standard. I hope that we don't appear to be self-conflicting. Even though we come up with this measure, we hope that we try to allow the market to self-regulate as much as possible. Let's say if you say that a minimum of 30% rent reduction is acceptable, that would be hugely controversial. And this will actually affect the execution of this bill, as both sides may not reach an agreement. According to Mr. Chair, well, let's say the landlord only offer meager reduction. Well, not just the landlord could make a unilateral offer. Both sides would need to reach an agreement. If there's only very superficial offer, and while the tenants enters the agreement, then this agreement would not be exempted from this law. Next, Ms. Eunice Young. On the temporary protection measures for business tenants COVID-19 pandemic bill, at the beginning, I was suspicious. Well, at first, I thought this cannot strike a balance between the landlords and the tenants. After some refinements, though, well, from what I see now, simply similar to what Mr. Low, well, in terms of the protection period, well, on the stipulated period and the protection period, what's the relationship between the two? According to clause 5 in the 4 of the bill, if by 1st of January and at the end of the protection period and on the day the lease applies, for any action arise, that will be, we fall under the list of forbidden action. Let's say you cannot chase rent during the 3 years. This seems to be quite self-contradictory. This is different from the landlord's expectations. In terms of promotion, you promise to clarify, or let's say that you just won't allow rent recovery action for 6 months. If you started an action before the commencement of tenancy, that you should be stayed. Actually, I don't have a chance to ask how can the proceeding be stayed. Should the landlord take proactive action to apply for a state of proceedings in the courts, or that if both sides decide not to act and simply let it lapse? Will the government consider on those cases already in court proceedings? And also, how do we prevent the tenants from abusing this proposal? There are some deadbeat tenants. For example, let's say the tenancy expired at the end of last year. However, they are still occupying the property, and you claim that from the 1st of January, landlords are not allowed to take any action. If the tenancy already expires, the tenants should not be staying at all, and yet they are. What can the landlords do? I heard plenty of stories on how do we prevent the deadbeat tenants to abuse this mechanism. Well, from looking at the bill, there is no mention on the commencement date of the tenancy. Well, at the end of the tenancy, what could be done? Would you consider adding more provision that only applies for active tenancy for additional protection? Mr. Chuck? According to Ms. Young, what the proposal the legislative the bill we tabled is different from the original version. The original version was 3 months, and however, the date of the REM is retroactive from 1st of January. In the budget, there's no mention of the 1st of January. After consultation that we have managed to put this date in the proposal, and we explained repeatedly why we would forbid the rent recovery from 1st of January. Since the fifth wave started on the early January, it came fast and furious. If we don't cover this period, that we will miss out a lot of the affected businesses. If the protection period starts from the commencement or the Gazetted date on the announcement on 23rd of February, let's say only upon the passage of the bill, for example, on 27th of April, there is a 2 months gap in which the landlord can take legal action against the tenants, which may force the lender to close. The second question on the commencement would only apply to active tenancies or valid tenancies. Well, on the proceedings, well, on class 6 bracket 3, if some of the legal action are the time limit action at the end of the protection period, well, the time of exercising the legal right will be delayed correspondingly. And similar arrangement also apply to lenders and mortgagees. For the so-called deadbeat tenants, hopefully we can pass this bill in the first half of this year. Well, we don't need to argue, and there's no concrete definition of deadbeats. Let's say some only paid 2 to 3 months of their rent and stayed in premises, and for those who fail to pay the rent for a few months consecutively, are they considered deadbeats? The difference between a non-domestic and domestic property, well, domestic property as a tenant, well, actually gained by simply staying in the property. For commercial premises, it's pointless to occupy the premise. You need to open your door for business and pay for the payrolls and other outgoings, etc. You need to pay for a lot of bills as well. So therefore, it is not completely free. If someone will start owing rent on September 2021, this bill allows a landlord to take action for the rent owned between September and December. If the landlords manage to the landlords can apply to possess their property. Mr. Long, I don't wish to debate with you. Well, this bill does not cover all business shops, only those affected by Cap 599. I understand. Well, in terms of the deadbeat tenants, I received complaints. Well, I hope they can provide me some examples of the deadbeat tenants. Well, usually the landlord can cut off the utilities. However, I don't want to debate with you on this. Next, Mr. Leung Chi Wing. Thank you, Chairman. I support this bill in helping the SMEs or the large business. so that they can tide over the short-term financial difficulties. I reiterate that this bill is not waiving the rent. It's simply providing a 3 months grace period to provide them with some breathing room. The FTU have received a lot the views of this business. They hope this bill can be ratified as soon as possible. Well, especially for the premises under 599, this bill can really help them survive this pandemic. For the past 2 years or so, whenever you go out in those core district like Mongkok and Tsim Sha Tsui, a lot of shops have closed down. This urban plight is damaging to Hong Kong and to our unemployment, and also will push up unemployment rates. This will simply harm our society as a whole. This bill allow the tenants in the height of the fifth wave that they'll be given 3 months so that they can wait for the pandemic to be over. Like it said, on 21st of April, some of the premises can reopen in phases, then they can operate in normal, and after bring in income, they can repay their own rent. I hope that the landlords can be more sympathetic and accommodating, and wish that both sides can reach a compromise to allow our society going forward. A lot of these shops closed down. It's actually hard for them to reopen. Lots of the shopping centers, for example, let's say some of the shopping malls after privatized or sold by the Link REIT, their shopping centers are not well redeveloped, and this poses a challenge for the residents. With the REM in place, we can protect these shops and protect some of the workforce. And this will be vital in preserving the vitality of the economy when we reopens. I hope that the Bills Committee can agree with the timetable provided by the government and implement it as soon as possible. As we all know, after the fifth wave, there may be the sixth wave coming. Will the government provide further measures to help the businesses? After the end of 3 months, when the sixth or the seventh wave arrive, will the government introduce similar bills? By then, the private sector and the landlords may object. Will the government have any contingency plans to help the various businesses? I hope that the government can provide early answers to them.
Yes, Mr. Chair. Mr. Lam asked what we should do should the sixth or the seventh wave strike. I think what he means to say is that would it be a waste of time if we are to enact the bill again because the 3 month protection period by the time will lapse? I think first of all, we need to be confident. We need to have confidence in our anti-epidemic effort. And fortunately, in the past 2 weeks, as confirmed by the Center for Health Protection, it seems that the epidemic situation is gradually under control, albeit that the level remains high. Now, unfortunately, if unfortunately another wave emerges in the coming 3 months, of course, we can rely on this existing bill. As to what happens beyond August, we at the same time need to address landlords' concerns as well. If we prolong the protection measure, it may not do good to both landlords and tenants. So I think we should just wait and see if another wave strikes again. It's too early to say. If by the time Hong Kong is in the doldrums, then consideration will be made then, and you can decide whether to support the government's measure again. At the moment, we believe the 3-month protection period is sufficient. Dr. Loy Kwok. Thank you, Chairman. Chairman, the Financial Secretary has put forward the rental enforcement mechanism and consulted members of the Business Professional Alliance. And we're happy to see that the Financial Secretary has taken into account the concerns we expressed and made improvements. Now the option of extending the protection period by 3 months has been removed. It is categorically clear that the protection period will last only 3 months. But like the other member said, the actual protection starts from the 1st of January. If we have a 3+3 arrangement, the whole period will be too long. Chairman, we only start examining this bill today. I have no idea when the bill will be passed and gazetted. Let's take it to be mid-April, all right? So it takes effect from mid-April, and if we set the counter to the 1st of January, then altogether the protection period will be one of 9 months. And I don't think it's reasonable. The government has listened to us and restrict the protection period to 3 months. Now, another member asked what should happen if we have the 6th and the 7th wave. Of course, this is not something we want to see, but if it really happens, I don't think it helps if we only penalize landlords. I don't think Mr. Chuck today will be able to tell you more about the possible 6th or 7th wave. Safe to say that, of course, it will be a major challenge for everyone in Hong Kong to move forward. Now, I'd like to focus on rent reduction. If upon agreement, the landlord reduces rent, the tenant at the same time has to make sure that he can pay the rent so reduced. And it's not for the government to force anyone to pay rent. I think earlier we put this question to the government without a clear reply. Let's say the protection period lasts from April to June. Mr. Chuck's reply is that, let's say between January and March, the parties came up with a new rental agreement, and that rent would be reduced, and that the tenant could afford the rent. Then between April and June, they could rely on the new rental agreement at the new rental level pitched. I think this is a feasible option. You can't force anyone to pay rent, but for the businesses affected by the anti-epidemic measures, I think this is one possible option. Mr. Long, along with other members, just now made another point. The purpose is to help SMEs. And amidst the epidemic, there are major enterprises that are very much afloat. And through this bill, they will be able to keep the rent that they're supposed to pay in their pocket for the time being, and this is unfair to landlords. It's just like the employment support scheme. The government's goal is very clear. It is to help SMEs. That is why I have the same question. I think we should focus the resources to help the most needed. Let me remind members that this bill will not be passed before the 27th of April. Mr. Chair, let me answer Dr. Lowe's last question. I don't think he needed a reply for the comments made. He talked about relief for major enterprises and that even if they could afford the rent, they would hold back the payment for the time being. In fact, as set out in the paper, there is this suggestion that we should define SMEs. And for example, the definition should be that it is not a listed company. An SME is not to be defined by the number of employees in employment. That is his suggestion, but as we know, even listed companies come with different sizes. And of course, Chairman, you are very familiar. We have listed companies running Chinese restaurants of different scales and running small to medium-sized establishments. So if we confine ourselves to SMEs and not offering help to other affected enterprises, it's not fair. Like what has been set out in the paper, it's not our goal to offer help to SMEs only. We suggest that we should help SMEs as well. As for the SMEs definition, we're talking about for non-manufacturing industries, enterprises employing 50 employees or less, and for manufacturing industry, below 100 employees. In some countries, they define SMEs as employing up to 500 employees for different sectors. So it is not easy to strike listed companies off the list of protected enterprises. For listed companies of a significant scale, in the current low interest environment, if they're able to afford rent, why shouldn't they pay rent? If you are late in paying up, then you will be required to pay interest. At the end of the protection period, a landlord can exercise his right to claim for rent in arrears as well as the surcharges. So it doesn't pay to do so. Having considered Mr. Long's point, we have set out in our reply to him that we have no plan to follow his suggestion and limit the bill to SMEs only. Next, Mr. Horace Zhang. In short, I think it's common knowledge how the epidemic is affecting different sectors. Some landlords are willing to cut rent for the time being, but in some cases, some landlords are quite reluctant. They are quite stubborn. Some landlords may be affected as well. For small businesses, perhaps they don't find the measure useful. At the end of the day, perhaps the best solution is to ask the government to pay rent on behalf of small businesses. However, this entails a significant amount coming from the public coffers. Some people are skeptical about the effect of the moratorium. I'm not sure, but I think it's better than none. And all in all, business tenants are now in dire straits, and it's not, sitting on our hands isn't an option. So I support the bill as well. I also note concerns and comments about interfering with the market and interfering with the private property rights. As explained just now, in other common law jurisdictions, there are similar arrangements. Now, I was also a member of a committee regulating first-hand residential properties. And back then, there were suggestions that the government's measure was against the basic law. But at the end of the day, I didn't see any lawsuit. I see this bill as a time-limited effective measure. The improvement of removing the option of 3-month extension would also help rein in risks faced by landlords, so that the risks would be basically manageable. About incentivizing rent reduction, I do think that the government has taken on board our suggestions, so I supported the bill. And now I have a question. In clause 5, bracket 7 of the bill, that is, actions landlords are barred from taking during the protection period. These are, for example, you cannot deduct from the deposit, you cannot recover interest or charge, you cannot terminate the tenancy. What about tenancy agreements that are subject to guarantee? Sometimes a landlord may need to make a pledge, may require the business tenant to make a pledge, or the director of the company will need to make a personal pledge, so that in the event of done the payment in, rent in arrears, you can go after the director. Now, is it covered? If we turn to clause 5, bracket 7, in subsection 7C, G, H, I, J, K, L, M, tenant in relation to tenancy includes the guarantor or surety of the tenant who incurs liability to the landlord, so on and so forth. So I think this answers Mr. Horace Cheung's question. And that is whether you can pursue liability against the guarantor. The answer is no. Next, Mr. Reverend Kuhn. Chairman, I think that this bill proposed by the government is really tricky for us. Of course, business tenants and SMEs are in a predicament, and we should have sympathy for them. At the same time, a lot of comments have been received. Meanwhile, when the government is winning a round of applause, LegCo members find it difficult to choose sides. I'd also like the government to explain the following. It seems that the government is robbing Peter to pay Paul. Is there a way to change this policy The 3-month protection period sounds too short. I agree with this suggestion. What about another round of protection measure? Is there a sunset clause? I understand there is. However, after the bill has been passed, what will the future for us if another epidemic emerges? This hasn't happened before. It is unprecedented, but now you've set the precedent. This may cause a certain perception to be formed. So you need to level with the public. And I do think that we all have our difficulties.
Well, on the surface, they may appear to be asset rich. However, they may have difficulties or their owner incurred a lot of liabilities. I hope that the government can provide the rationale of this policy. Mr. Check. According to Mr. Kuhn's question, whether this measures in breach of the sanctity of the contract. When explaining to other members, well, Singapore and the UK have introduced similar measures. I try to find some negative criticism of accusing them of breaching the rule of law. So far, I haven't found any negative voices. Well, the name of the bills illustrate this has to do with COVID. It's just extreme measures for extraordinary times. The financial secretary clearly stated that this measure should only last for 3 months. However, the expiration will straddle to the next term of government. For the next term of government, they will proceed carefully if they decide to roll out similar measures in the future. That's why we stated it only lasts for 3 months. According to Mr. Gunther, whether are we robbing the rich to pay the poor? As I said, after many rounds of consultations, we stressed that we're not polarizing particular social class. We are aware there's an actual need to safeguard enterprise and save jobs. Instead of portraying this as an ideological move. Any follow-up? None. And that's the end of the first round of questioning by 16 members. We're now open for a second round. And let me read out the list of members who put up their hands. Kwok Wai Kang, Ronnie Chen, Chan Siu Hong, Doreen Kong. 5 minutes per round. Mr. Kwok Wai Kang. Thank you, Chairman. My second round question is quite straightforward, mainly about the timing. We all know that all of these relief measures should be implemented as soon as possible. Let's say for the AEF, for the employment support scheme, as well as just temporary protection measures should be enacted as soon as possible in providing timely relief. May I ask the administration any timeline you need to highlight? That when is the deadline we need to pass this bill? If we cannot pass in time, what's the impact of this bill? Would it reduce its efficacy, or there will be other derivative effects? I'd like to hear from the administration. Mr. Check. In my opening remarks, we stated our position on the legislative timetable. if the members not, let's say on the 8th of April, we can report back to the House Committee. And on that day, we will issue a notice that we shall resume the second reading at the council on 27th. Why the April 27th? As we need to give 12 clear working days notice. If we cannot meet this timeline, the longer the bill is dragged on, then its efficacy will be undermined. As we all know, the economy is in dire straits. We hope that we can offer timely relief for struggling businesses. The later it is enacted, well, it will harm the tenants as well as the landlords, like many members have said. Since the rental enforcement moratorium starts on 1st of January, I need to make this clear. I'm not threatening large edges. Well, since Mr. Kwok asked for the scale of the actual impact, well, if it's dragged on too late, we might forget about it. If we pass this bill too late, well, if the business decided gone over and the defaulted rents is piling up, and this will pose a bigger risk to landlords. Therefore, if we pass this bill before May, that would be the most desirable. Well, just now Mr. mentioned if everything goes smooth, then this could be put to a vote on the council on 27th of April. Let's say it dragged on till May before passage. Sadly, the 1st of January commencement date will not be changed. Well, the late date of enactment data protection period will be extended from 5 to 7 months. Yes. Well, Mr. Kwok, let me offer my opinion. This bill not just protect these SMEs tenants, the small landlords. If some of the tenants fell behind the rent, I believe there are plenty. If they cannot service the mortgage, the enactment of this bill can also save the smaller landlords from being pursued by the lenders. I believe that this bill's passage will be beneficial. Unless you say that we have enough votes and we can object, then you feel free to do so on the second and third reading. Thank you, Mr. Ronnie Chan. Thank you, Chairman. Like Mr. Kwok said, I just have a straightforward follow-up. In this bill, you're barring the banks from taking such action to list running from A to I. Pardon me. Well, actually, it lasts all the way to P. When drafting legislation, how you make reference to other lender restrictions measures in overseas jurisdiction, are we stricter or more lenient than other jurisdictions? If the owners can reasonably establish that the failure of the tenant to pay their rent and the landlord's right are being barred are the sole reason or subjective reason for inability to avoid the repayment default, would you let the HKMA to issue guidelines? Let's say some landlords own a lot of properties and some of them are real, some of them are still making rental payment on time. If the landlord cannot make the payment, who will decide? For your first question, we discussed it previously. Mr. Chair, maybe you can give a succinct answer and get to the second question ASAP. For the second question, question. Well, we have an HEMA representative here. I'll leave it to them for the first question. First, I wish to state we're not copying from certain places. Well, for Mr. Chen, we've examined various jurisdictions. Take Singapore and UK, for instance. For the Singapore initially rolled out less restrictions, and they put in more over time. Today is the 1st of April. Back in March, they did wish to pass an act to put in more restrictions. And Mr. Chen claimed that the list lasts from A to P. Well, of course, that. Well, take Singapore, for example. They provide exhaustive list of restrictions, which is similar to Hong Kong. And to suit local circumstances, we also add a few of our own. Therefore, we're more exhaustive than Singapore. I hope this answered Ms. Chen's question. For your second question, I'll defer to HKMA representative. Thank you, Mr. Chen's question. The landlord has a duty that to establish that due to the laws speaker not speaking clearly. From the HKMA's perspective, we'll request banks to take a more accommodating approach. If they notice that the landlord is in actual difficulty, they should take a more accommodative approach by providing more space to tide over difficult period. In case of dispute, the HKMA all along has provided SME hotline, and they can call us, and we're happy to provide assistance. Any follow-up? None, thank you. Next, Mr. Chen Xiu-Hong. Thank you, Chairman. Well, before the cluster plot examination, I want to talk about some policy issues. According to Clause 5, even it states the period of protection will start with the commencement date and last for 3 months. And during the protection period, the landlord cannot take action for the rent until the end of the protection period. If the bills enacted on the 1st of May, then the protection period shall last for 31st of July. Then the landlord cannot receive the rent for 7 months. As for those landlords who rely on rental income, the government claims it will provide the 100% personal loan guarantee scheme to provide the interest-free loan equivalent of 3 months worth of rent and the ceiling of $100,000. Well, they only get $100,000 interest-free loan during the 7 months period. This is not proportionate. Would you consider amending the period of interest-free loan to tally that with the protection period?
I've answered the last question many times. The question was, why should the date be set at the 1st of January? I'm not going to repeat the answer, but let me turn to some extreme cases. What happens if a landlord fails to get paid rent for 7 months? Under usual, under normal circumstances, a landlord can take action afterwards and also against probably a guarantor. even without this bill, the risk still exists. The bill only asks for deferral of the legal actions involved for 3 months. In any case, we encourage parties to make use of Clause 4 so as to negotiate a new rental agreement, including rent reduction and repayment of rent by installments after the lapse of the protection period to minimize landlord's risks. And about the maximum loan amount of equivalent to 3 months of the rent amount subject to $100,000 ceiling. There is an allegation that at the end of the day, the landlord will still have to pay up. But then, as I understand, they can pay over a long period of time. And in that sense, we can help manage the risk. I just want Mr. Check to consider this. We're not talking about an amount equivalent to 3 months rent, but more. Especially, say, if the tenant is unable to pay rent for 4 months, let's pack it to 4 months. Right. The question is not whether the government pays up. The question is whether the government can align the two the periods in the two schemes. Mr. Chuck. Application for a loan can be made under the 100% personal loan guarantee scheme. It's not about the government paying rent on behalf of the tenant. Do I still have time, Chairman? I'm not sure, but what's your question? This is the third round. Just go ahead. Okay, I'll wait for the third round. No, just go ahead. This is a question and also a reminder for the government. You need to manage expectations. After the Financial Secretary delivered the budget and floating the rental enforcement mechanism, there have been a lot of views expressed in the company, in the community. I understand that landlords of residential properties are also concerned. Many employees are put out of job in the fifth wave. They have problem paying rent, and this is a precedent. People have expectation that this moratorium can be extended to domestic properties. So what is your take on managing expectation? How are you going to level with the public? How are you going to explain the bill? Are you going to make it very clear where the line is drawn? Are you trying to ask whether the bill will be extended to domestic properties or what? I'm talking about unreasonable expectation. Okay, something about, well, please let me finish. Don't interject. I'll give you time. Right, it's your turn. Sorry, Chairman. You're right. My question is that the government should manage people's expectation. Mr. Chuck, in short, we have no plan at all to extend this protection measure to domestic properties. Next, Ms. Doreen Kong. Thank you, Chairman. Mr. Chuck, I have a number of questions for you. First, on the point of fairness, according to the bill, rent includes rates, government rent, and other miscellaneous charges. Have you considered this? Let's say if the business tenant is not paying up whilst using the property, the landlord will still be required to pay all these utility charges, rates, and rents. For commercial properties, there are numerous surcharges, and in tenancy agreements, sometimes they are not included. Will it be unfair to small property owners? Now, if this is your thinking that small, business tenants will pay surcharges, albeit defaulting rent, why don't you spell it out in a bill that even if they enjoy the moratorium, they will still be responsible for paying surcharges upfront in order to make it fair for small owners. The other point is also about fairness. Landlords will be required to prove the overall financial status and the severity, how heavily they're impacted by the repayment default. Business tenants are not required to prove their inability to pay rent, whereas landlords will be required to prove their inability to repay mortgage to the banks. So in all fairness, you should also spare landlords this requirement of proof. That is the basis on which I make my amendment. About the Lands Tribunal, Mr. Chuck, we all know that inevitably, once the protection period of the bill lapses, there will be more cases of dispute, and you have to clear the backlog. Mr. Chuck, have you asked the judiciary, for example, whether the Lands Tribunal has the capacity to handle all these cases a few months on? And about overseas mechanism, Mr. Chuck referred to the UK and Singapore example. I went through all the rental enforcement moratorium laws around the world, but I don't think we have adequately copied from other countries. Apart from the protection measures, they have a mechanism. For example, in Singapore, they have assessors. A few days ago, the UK enacted an act for mandatory arbitration proceedings to help resolve disputes between landlords and tenants. Mr. Chuck, has the government considered these measures? Because otherwise, how would the government help resolve disputes between the two parties? Another question. We understand the protection offered under this bill. It goes from the 1st of January to the end of the protection period. And yet there is also another term called the affected period when it comes to dunning rent in arrears. Why can't the same protection period apply to landlords as well? Instead, you come up with a new term, the affected period. Let me take the last two questions. We have a protection period. We have something else called the affected period. Because the bill provides that the protection period starts from the date of commencement of the bill for 3 months. However, for the affected period, it may go beyond 3 months. It depends on, say, when the bill applies to the premises. The actual affected period may be shorter than the protection period. That is why we want to introduce a new concept, the affected period, as well. That is a period in which when the law applies. About overseas mechanism, such as assessors, arbitration proceedings, as you mentioned, our thinking is this. For other countries, the protection period is more than 3 months. In the UK, if my memory serves me right, the period lasts for 2 years, leading to a lot of disputes and the need for arbitration. But like I explained, this bill will only be effective for 3 months. And we'll try to make this bill as simple as possible, especially in terms of enforcement. Otherwise, if we have elaborate procedures such as assessment panels and arbitration proceedings stipulated in the bill, I don't think this is proportionate to the bill itself. As for the point of fairness, why is it that a landlord is required to prove, according to the bill, by way of reasonably establishing the following? That is, the landlord is unable to receive rental income because of this bill. Our philosophy is that it would be relatively easier for a landlord to prove that he's affected by the protection measure. Let's say, take a look at this, the bank statement. If you can show a few bank statements showing that you no longer receive rental income as you've done in the past few months, then you can easily prove that you've been affected by the protection measure. Whereas on the part of a business tenant, if we require the tenant to prove that he is incurring a loss before he is eligible for the protection, it will be relatively difficult, as a lot of information would be involved, some of which would be commercially sensitive. That is the reason why we haven't imposed the requirement in the bill for the landlord to show proof of profit to loss. Let me address another point. Well, Ms. Kong, rather, your question was, right, I was referring to rates and government rent and other surcharges. For commercial properties, well, I know that the government will have another version, but what about management fees? The government said it will not go after the landlord for rates and rents, but what about management fees? For commercial leases, the mainstream practice is not for the landlord to be responsible for utility charges and management fees. Say if you're in a catering business, you expect to receive a hefty utility bill. Right, understood, Mr. Chang. But does it mean that under the bill, the landlord will not be able to pursue anything? Like you said, for commercial properties, these charges usually are paid by business tenants. If the landlords cannot go after the tenants in these areas, I understand the point about rates and government rents, but what about utility bills, water, power bills? It's only reasonable for business tenants to pay upfront if they want to do business. Even if they're unable to pay rent, it's reasonable for them to pay utility charges. Right, Ms. Kong, please allow the public officer to reply first. Let me help out. My understanding, Mr. Chair, is this. This bill is about rent. For matters outside rental matters, well, I understand that sometimes the landlord or the rental arrangement covers rent itself as well as surcharges and rents and rates. But let's say if we have separate charges such as AC charges, utility, water, power, they may be calculated per square foot. So this bill will only cover the part about rent. Does it mean that the landlord will still be able to ask for payment of other surcharges?
Chairman, your understanding is correct. If it's not covered in the rental agreement, like utilities and other outgoings, that must be borne by the tenants themselves. Ms. Kong may think some of the tenancy agreements may cover those management fee, etc. Like I said at the beginning, this is not in the mainstream, but even in this case, okay, this may sound unpleasant. When a landlord drafts the tenancy agreement, they need to consider whether they need to cover all kind of other expenses. Of course, this will mean a higher rent. While this will entail the risk of, well, in case of default, even without this bill, the landlord will be out of pocket with his expenses. But at the end of the day, we should make good use of these exemption clauses and work out an agreement. Let's say I pay some of the rent in return of a rent cut to resolve of the future rental arrangements. Ms. Kong, any follow-up? Nothing, I'm good. I don't see any members wishing to speak, and we have completed 2 rounds of questioning. If we finish discussing the policy matters related to this bill, then we shall start with a clause-by-clause examination. And please refer to the following document, the blue bill, CB bracket 3151/2022. And item number 2, the letter from the assistant legal advisor to the government, LC paper number CB bracket 1142/2022 bracket 02, as well as the administration's reply to assistant legal advisor's letter dated 25th of March 2022. That is LC paper CB bracket 1153/202201. Mr. Chuck, shall we invite the administration to go over your reply to the assistant legal advisor? Let me hand over to Mr. Andy Lam to respond. And yesterday, we have replied to the matters raised by the assistant legal advisor. And let's start with the first paragraph. While on the specified premises, whether the certain premises need to be used wholly or primarily as specified premises. Well, we understand the legal advisor's point that we should need to determine based on the particular facts and circumstances and taking a common sense approach. For example, the size of premises designated for use as specified premises, as well as the takings of the relevant business as a portion of the entire business. However, it's not possible to sell it exhaustively to circumstances. We shall stick to the facts and the circumstances as a rule. Any members have question regarding the administration response? If not, we shall enter clause by clause. And who will be responsible? That will be Mr. Lam as well. Let's start with the long title. And for clause 1, that's the short title, and 2 is the interpretation. And these are the definition of the common terms. And well, let's see, do we have any questions? Well, I will interrupt you to see if any members who paid up with their hand. Long title. To provide for temporary protection measures for business tenants adversely affected by the COVID-19 pandemic and related measures required for the implementation of such protection measures and to provide for related matters. And the short title, Temporary Protection Measures for Business Tenants, bracket COVID-19 Pandemic Ordinance. Let me stop here first. Any question from members? Please carry on. Clause 2 interpretation. I probably would not go through them one by one. Well, these are the common terms used throughout the bill. Well, of a protection period means the beginning of the commencement of the date of the ordinance and any of the expiry of the months beginning on that commencement date. But the specified premises means any premises specified in part 2 of the schedule. Ms. Kong, you have a question? You put up your hand. Thank you, Chairman. On the definition of tenancy, I know include oral or written tenancies. 3 questions. Does that exclude license? Let's say a usage license for a property. In my amendments, I mentioned, can we make it explicit? Besides the lease, you should also cover tenancy agreement. According to the law, there's a difference. Well, for lease running over 3 years, we call it a lease. And for those shorter than 3 years, we call them tenancy agreement. I don't want this small landlords to get into any dispute. We'll also cover short-term tenancies. For example, those lasting for a few months will also be covered. Just want to make it clear. Mr. Lam. Well, license is not included. Well, lease will include tenancy agreement. For the second question, in reply to the legal advisor that the lease should cover tenancy agreement. Therefore, we don't see it's necessary to state it explicitly. For the third question, will any mention of a lease or tenancy agreement are included? And there's no mentioning of the length, the duration. Ms. Kong, any follow-up? Thank you. I urge the administration to take a look that there are other kind of legislations. For SLR can be using a property ordinance, Cap 219, and a landlord and consolidation, and landlord consolidation ordinance that is Cap 7. Can the government take a double look when defining the tenancies, or you only stipulate them as leases? Just want to minimize the confusion. Mr. Lam, have you checked the relevant legislation? I'll let my drafting colleague to respond. And thank you, Ms. Kong's question. When drafting for the definition, with reference of the 2021 Landlord and Tenants Consolidated Amendment Bill, the definition of a tenancy tally with that of that other bill. And there's no mention of tenancy agreement in that bill too. Any further questions, Ms. Kong? No, thank you. Mr. Lewis Long. Thank you, Chairman. On the interpretation, I said that this bill defined the specified premises through the schedule, which encompasses many types, including the large commercial tenants that are unaffected by the pandemic. Therefore, I suggested that in the interpretation section, you add the definition of the SMEs, and the suggested wording well, using the same wording on the eligibility of SMEs under the FSGS. And for the definition of the tenants, you should also stipulate that as SMEs. And definition of the tenancy should state that the SFGS that's already incorporated in my draft amendments by myself. Mr. Long, the administration has replied to you in this regard. I'll let them answer you again. I'll leave some time for you to explain your proposed CSAs to see if your colleagues support your CSA or you decide to move the CSAs at this second or third reading. Who in the administration will end to reply to the proposed amendment by Mr. Long? Just a quick response. Just now, Mr. Check mentioned why we need to differentiate SMEs and other type of tenants. And I'll reply to the legal advisor. We explained the grounds of why we cannot accept Mr. Long's amendments. Like the chairman said, at the CSA stage, maybe we can have another in-depth discussion. Mr. Long, any follow-up? Nothing further. Next, Mr. Kong, you have something else? Yes, it's not a follow-up. I'd like to ask another question. On the definition for loan agreement, may I ask the colleague responsible for the drafting in English in relation to a loan? For the commercial property, sometimes there might not be a loan, but instead some kind of trade facility. It's one of the all types of credit facilities. With the term be too narrow, if you confine it to a loan, should you cover other kind of bank facilities as well? Thank you. Mr. Lam, our understanding they should be covered. I'll let the HKMA to supplement. And thank you, Chairman, and thank you, Ms. Kong. The loan will cover all kinds of overdraft lines and trade financings. So long as the loan are covered by a security, then they will be covered by. Does that include I pledged my property for a credit line, and when I draw the credit line and yet I have yet to make repayment, is it covered in the loan agreement? Thank you, Chairman. Well, when I get to clause 7, then we'll get a much clearer picture. When we talk about the secured loan, the loan in question will be protected by this bill. It didn't say that it must be a secured loan or a credit facility. So long as the loan is backed up by security, that they will be covered by this protection.
Ms. Kong, any follow-up? No, thank you. Any other members? Mr. Lung? On clause 2, do you have other questions? No, I'd like to follow up on the HKMA's question. The explanation is that in relation to the loan agreement, Will overdraft facility be included? That is, whether loan includes overdraft agreement. Who will take the question, please? Thank you, Mr. Long, for your question. As I understand, loan includes overdraft facility or other forms of loan. Okay. Mr. Long, any follow-up questions? No, thank you, Chairman. No more questions from members on this clause. We move on to clause 3, application of ordinance. Mr. Chuck already explained, for application of ordinance subject to section 4, this ordinance applies despite A, the provisions of any other ordinance, B, the terms of covenants of tenancy, and also any other documents in relation to a tenancy. That's about application of the ordinance. It has overriding nature. Any questions from members on clause 3? Ms. Kong. Thank you, Chairman. Hypothetically, my question is this. For clause 3, if the governing law is law from another jurisdiction, and it sometimes happens for commercial properties of a certain scale, does it still override the loan documents? Because the loan documents sometimes would be governed not by Hong Kong law. Who will take this question? In these circumstances, notwithstanding the relevant tenancy agreement stipulating that it is not to be governed by Hong Kong law, it still applies. That is according to clause 3, the bill applies. The governing law of the tenancy as stipulated only governs the content of the tenancy, including the rights and obligations. Clause 3, however, overrides the governing law. Ms. Kong, a follow-up question? Yes, Chairman. I'm not too concerned about tenancies not governed by Hong Kong laws, but there are mortgages involving overseas banks and loan agreements of the similar nature. So in these circumstances, they are not governed by Hong Kong laws. So my question is, how do you make sure overseas banks won't go after local landlords based on this bill? Anyone from the HKMA? Who will take the question? The DOJ colleague, Ms. Chan, will take the question. Thank you, Chairman. The applicability of the laws of Hong Kong in relation to a tenancy agreement or a security agreement is not determined by the stipulations in the tenancy agreement. So no matter the governing laws stipulated in a tenancy agreement, in interpreting the tenancy and in resolving disputes, it doesn't affect the applicability of the laws of Hong Kong. Any follow-up questions, Ms. Kong? No, thank you. Okay. No more questions on clause 3. We now move on to clause 4, contracting out. There are 2 parts to clause 4. Basically, during the protection period, whether between a landlord and a tenant or a lender and a borrower, then in respect of the time when any rent is payable or the amount that is to pay as rent, when a written agreement is entered into, then this ordinance ceases to apply in relation to a tenancy or a loan. Mr. Holden Chow. Chairman, thank you. I have a question on clause 4. I understand that in terms of forbearance, the written agreement being entered into between the landlord and the tenant is that, first of all, the rent is to be reduced and the time when the rent is payable will be deferred. I don't know whether the administration has considered this, because for the sub clauses A and B, I see this word or. So does it mean that even without reaching an agreement on rent reduction, as long as a landlord agrees to receive rent at a later date, this will already carve out the application of the bill? Perhaps I am taking the SME's perspective. I wonder if the administration would consider changing the word from or to and, so that you have rent reduction as well as rent repayment deferral. Mr. Lam, like Mr. Chak explained just now, I think that depends on the agreement to be reached between landlords and tenants. We'd like to allow more room for them to enter into agreements, because the circumstances of each tenant or landlord differ, and it's hard to say that you need to fulfill both A and B before the ordinance can be carved out. So I think it's more suitable to use or here. Mr. Chow, any follow-up? Okay. No more follow-up questions? Now clause 5, protection period. Clause 5, protection to tenants during protection period. That's the core of this bill. Subclauses 1 and 2 relate to 2 scenarios. First, where a tenancy for premises commences before the day on which the protection begins, then subsections 4 and 5 apply in relation to the protection period until the period has expired or beginning of the day on which those subsections cease to apply under subsection 9. Subsection 2 relates to where tenancy for premises commences on or after the day on which the protection period begins. And the protection period applies when it lapses or the beginning of the day on which the subsection ceases to apply under subsection 9. This is in relation to Ms. Kuhn's point just now. Perhaps I'll pause here. Go on. Subsection 3 is another scenario. Say if the tenancy has already come into effect, and then on a day during the protection period, if a type of premises is added under section 9 of the schedule, that is the premises is only added subsequently to the schedule of the bill later, then it applies on after a date in relation to tenancy that until the expiry of the protection period or the beginning of the day on which it ceases to apply under subsection 10. Are we going to go through 4 all the way to subsections 11 before I allow members to ask questions, or should you address members' questions now? I see hands in the air. I respect the chairman's handling. I see Mr. Horace Chang's hand in the air. Are you going to ask a question relating to the clauses we covered? Right, I can start now. Chairman, you talked about this clause being the core of the bill. It's about protection to tenants during protection period. The key word or the keywords are if the premises are used wholly or primarily as specified premises. Now, let's say a landlord leases a property as an office, and without the landlord's knowledge, the tenant then operates the premises as a specified premises. Then, if the landlord then takes legal action, will he be in breach of clause 5, that is to pursue repayment default during protection period? I'll give a brief reply and then the DOJ colleague can supplement. In essence, we consider whether the premises is used as the specified premises as set out in the schedule. If so, it's protected. I'll hand it over to DOJ now. If the premises is used to operate business, well, I think Mr. Zhang's question is, at the time when I rent the property from the landlord, I didn't run it as a scheduled premises. Then I operate the business as a scheduled premises without his consent. Then will I be able to take legal action? I think we can interpret this as a strict liability offense. If the premises is used as a specified premises, and if you take action against repayment default, you will be committing a strict liability offense. However, in the common law system, the defendant can rely on the honest belief defense. Let me supplement. If the landlord takes action against the tenant not because of any repayment default, but because of breach of a tenancy agreement, then this bill doesn't bar landlords from taking such actions on these grounds. This bill only relates to legal action taken by the landlord in relation to repayment default during the protection period. Mr. Horace Chang. So does it mean that if I am a landlord and if I take action against repayment default without knowing that it is run as a scheduled premises, that I'm not in breach of the law? Consideration be given to the actual use of the premises, whether it can be regarded as a specified premises. As for the landlord, whether the landlord has knowledge of the use of the premises, this is rather a point on liability. And I think Mr. Lee just now already explained. In other words, if I were the landlord, I would have to put up a defense that I had no knowledge. Is that the point about the criminal liability? For this offense, there is no requirement to prove so. However, about the justification to be put forward by the landlord in a particular case, that depends on the circumstances of the case, whether it can be accepted as a defense.
we need to be very clear on this because a lot of landlords may not know how their property is used. I hope that you can explain clear at a later occasion. Ms. Kong. Thank you, Chairman. First, I want to talk about part 1, 2, and 3 of part of clause 5. First, well, the premise cover all kind of land use, let's say domestic, industrial, or lot. Well, some other members ask, how to define primarily used? Is it 80% or 90% or 60%? How to define primarily used? Well, a lot of the tenancy agreements only stipulate a commercial use or legitimate of legal use. Do not a further breakdown, for example, on whether we use as specified premises. How could landlord prove this? Just now, Mr. Horace Chung had a point. Sometimes, let's say industrial building could be used as restaurants or tutorial centers. It's not clear that whether this law will protect the tenant as well. May I ask Ms. Chen that those tenants will not be protected, that according to 5(8), that the landlord is not barred that under subsection 4 or section 6 will continue to take any action on the ground other than the tenant's failure described in subsection 4 or 6. If they violate the use agreed in the tenancy, they can still launch action to recover lost rent. Well, you raised a further question further down the clause. Okay, thanks for the reminder. Well, 5(2), that even within the protection period for the tenancy that commences on or after the date of protection begins, they could still be protected. If this law is enacted, then this is a new tenancy agreement or renewal, and they are well aware of this law and yet decide to enter a tenancy, do need to consider the rent and why are still protected by this law. It seems that it would be quite inconsistent with what Mr. Chuck said. You're encouraging people to enter an agreement. If the tenancy commences after the protection period begins, should they be excluded from protection? Otherwise, it will be against the object of this law. And on clause 5(3), then the government can add for any type of premises as they see fit. Well, would that bring uncertainty to the landlords? The government is free to add any types of premises, or it's just a matter of drafting that the government would not add new type of premises as well. Mr. Lam? Like I said, the core of the provision is on the usage. The word is used as designated premises. Therefore, the type of the land or the zoning of the land is not our key concern. So long as the premises is used as stated on the schedule, that will be covered. So where they are wholly or primarily used as specified premises, and according to the administration reply to the legal advisor, we mentioned that what constitute primarily used it. We need to look at the circumstance and the facts there. For example, the size percentage or the income from the specified premises as a proportion of the entire premises. We need to look at the facts instead of come up with a hard threshold. If the premises were not used as intended at their specified premise, will they lose protection by this bill? On 5 bracket H is relevant. If the ground is other than the tenant's failure to pay rent, then the landlord is not barred from taking action. I suppose that the action taken by the landlord would be to apply for the power of entry or tenancy termination. Usually, you're in breach of the use specified in tenancy. That's the usual legal consequence. Well, when it involves illegal use, there will be appropriate legal provision to take legal action. Well, for this bill, the aim is to make the landlord not to take legal action on the grounds of a tenant's failure to pay rent. The intention is not to bar the landlord from taking other kind of actions. Do we have a percentage of what constitutes primarily? Is that 50 or 60 or 70%? Does that mean 40% shouldn't count as primarily? Let's say 40% as catering establishment, 40% as tutorial centers. What will happen, Mr. Chuck? Let me offer a consolidated response to Mr. Horace Chang and Ms. Kong and you. For your question, Mr. Lam explained earlier, it's hard to draw a line on what constitutes primary. It's hard to draw a line or a specific percentage or above 60 or 80%. Instead, according to the chairman, let's say a 40%, it's hard to argue. Well, it's all common sense. If we claim you're primarily as 40%, so what happened to the 60%? And how do you explain this is the primary usage? As for how the landlord can prove vindicate its usage, first, they need to provide a business registration. And also, we can see from the shop front is a kindergarten. It looks like a kindergarten. If it's a tutorial center or a hobby classes, it should look like one. And some of them require obtaining certain licenses or certain kind of qualifications or proof. That's one way to see how the tenant is using the premises. According to Mr. Horace Cheng, let's say I lease an office to a tenant to engage in a certain type of activity. However, the tenant uses that space as a specified premise. The general principle is that, first, in your tenancy agreement, have you stipulated the use? Have you stipulated the usage? Let's say let's say from a non-specified premise to specified premises, there'll be a breach of the tenancy, as I expressly forbidden you from turning into other uses. If, let's say, I won't stipulate the use of the office, however, the tenant could not violate the deed of mutual covenant of any breaches of the DMC. According to the DOJ colleague, this is not a matter of rent and arrears. This is a matter besides defaulting in rent. Therefore, there is some protection for the landlords. Let's say there's no mention in your tenancy agreement and the activity the tenants are undertaking should not be a specified use without violating the DMC. It's been using at a specified premise. That in this kind of tenancy, well, this law will apply. Just want to make it clear. Any follow-up? I can't hear you. Yes. Mr. Chuck, you claim it's hard to draw a line in terms of primary use. Well, the landlord may stand being sued if there's no clear guidelines. For instance, back office, let's say it's used as the back office of the specified premises or as a warehouse. Does that mean that we can't recover the rent? I don't want to challenge you. I just want to hope you can make it clear. Since this draft we intend to help commercial tenants, why do you make it explicit that the premise must be commercial ones? Mr. Chuck? Yes, Chairman. In reply to Ms. Kong, it's not that it's impossible to prove. Let's say 60% or 70%. If you ask the government why they set it as 60 or 70%, even though you wish the government can be clear, well, let's say if you reach a certain threshold, then you will be called a primary use. Well, this is rather subjective. Well, the spirit of the legislation is clear. It's called well, the focus is primary. Well, you may not support whatever you said. You have repeated many times. Let's move on to another part of your question. You can explain why can we just explicitly make clear of limiting to commercial premises? Like Mr. Lam explained, whether it's a specified premise, well, the key is its usage instead of describing as a land or a factory building. Let's say it's a domestic property and use it to run, let's say, a private restaurant. In this case, it will be in breach of the building's DMC. In this case, the landlord can take action to the breach of DMC and the tenancy. Let me explain. Well, the progress is slower than I anticipated. Therefore, I'm not asking that whether we should extend it to more than 15 minutes, which is just caring for another 15 minutes. And please be succinct. You will get the same answer no matter how many times you ask. You will always be unhappy and you are free to move your own CSA. And the administration could keep dismissing you. Hope we can make good use of your time. Ms. Kong, any follow-up? Nothing further, Chairman. Next, shall we move to clause bracket 4? And under 5.1, if the tenancy commences before the protection period, that different specified periods from the 1st of January to the earlier of the following, the expiry of the protection period, or B, the beginning of the day which the subsection ceases to apply in relation to the tenancy under subsection bracket 9. During this time, the landlord would not take a legal action prescribed in 5(7) for the rent in arrears. And for 5(5), if some of the action already commences before the protection date and yet to conclude before the end of protection period, then the proceeding is to be stayed until the earlier of the following, the expiry of the protection period or the beginning of the date in which a subsection and the subsection 4 is to apply in relation to tenancy under subsection 9.
Subsection 6, according to subsections 2 and 3, in relation to tenancy that takes effect after commencement of the bill, according to subsection 6, they will begin on the date on which this subsection becomes applicable, or ending on the earlier of the following, the expiry of the protection period, or beginning of the day in which this subsection ceases to apply in relation to tenancy under subsection 9, and that no action should be taken in relation to subsection 7. And these are the actions I am not going to repeat. They include rent in arrears. Ms. Kong. Ms. Kong, for clause 5, subclause 5, any action taken by the landlord when the, or if pending, is to be stayed, so on and so forth. Why is it so harsh? If the proceedings have already begun, why should it be stayed? And there are different stages. For example, if a claim has been filed and if an award has been given, it still has to be stayed. The next point is about the word stay, or in Chinese, 擱置. Stay means that you put an end to it. Can you explain more clearly about the diction? First, on the point whether it is too harsh, the legislative intent is to protect tenants so that you have a rental enforcement moratorium, and meanwhile they will stay liquid. If we remove this provision, and that once an action is initiated, it can go on, the natural consequence is that since a bill was announced, many landlords would be filing lawsuits. And this is against the legislative intent. That is why any action already initiated should be stayed meanwhile to provide adequate protection to tenants. About the wording, I'll defer to the DOJ. Let me supplement. About the English word stay, in Chinese, the word 擱置 is used. This is a common corresponding term for the English text stay in different pieces of legislation. Subsection 7 refers to different actions, such as A and B. These are actions not of a legal nature. So we prefer to keep the general term. The word 擱置 or stay in English means that it should not go on in general. Any follow-up question, Ms. Kong? Next, Mr. Chen Xiu-Hong. Thank you, Chairman. I think my question is the same as the first point made by Ms. Kong. That is, the landlord is barred from taking actions listed in subsection 7, including terminating policy, is terminating a tenancy, etc. Now, my specific question is this. What if the landlord has already sought a ruling from the court before this bill commences? Does it mean that the action will be put to a halt, including the relevant proceedings in which one party has already obtained a court ruling? Mr. Lam. For subsection of clause 5, it sets out the actions to be barred, such as I, H, arbitral proceedings, bankruptcy petition, and then J, meeting of creditors, K, a winding up petition, distress, etc. This is about execution of the court's ruling. So this is a prohibition of enforcement of judgment. Any follow-up, Mr. Chan? Right. In fact, we're still on subsection 6, but you've moved on to subsection 7. So any other questions on 7? No, then subsection 8. Similar to my answer to Ms. Kong's question, subsection 8 provides that the landlord is not barred from taking action on the ground other than the tenant's failure to pay rent. Ms. Kong, do you have a question? Yes. Clause 5, subclause 8. What if a tenant fails to pay rent and breaches other terms of the tenancy agreement? According to clause 5, subclause 8, he will not be offered protection. Is that right? Because of how subclause 8 is drafted. Mr. Lam. The legislative intent is to bar landlords from taking action on a ground other than the tenant's failure. Not barred, other than on the ground of the tenant's failure to pay rent. Any follow-up? No, thank you. Next, subclause 9 of clause 5. Subsections 4, 5, and 6 refers to scenarios under which it applies, and as explained a number of times, whether it should apply until the expiry of the protection period or the scenarios mentioned in subsection 9. Subsection 9 refers to the scenarios where it ceases to apply, and that includes termination of a tenancy or a tenancy expiring or comes to an end on other for other reasons, and that C, the premises are no longer used wholly or primarily as specified premises, or the specified premises are removed from part 2 of the schedule. Under such circumstances, the subsections 4 to 6 cease to apply. Ms. Kong. Chairman, my question is on 9C. The premises, specified premises are removed from part 2 of the schedule. Let's say if the chief executive relaxes social distancing measures, will the specified premises be removed from the schedule? Mr. Lam, there is no causal link. Whether it will be removed from the schedule depends on whether the specified premises are affected by the anti-epidemic measures. This is something to happen in the future. But now, the specified premises have already been hit hard by the anti-epidemic measures, and they deserve protection. There is no direct correlation of the two. We need to keep it there. Otherwise, some tenants originally enjoying protection will no longer be able to do so. We're talking about a 3-month protection measure in this bill. Ms. Kong, do you have other follow-up questions? No. Clause 10. Clause 10, penalty. A landlord who contravenes subsections 4 and 6 and continues to take action commits an offense and then is liable to a fine that is equal to twice the amount of the rent claimed, and in any event not less than $50,000 unless the court considers that imposing a lower fine is just and equitable in the circumstances. No problem. Next question. Next subclause 11. Tenant, as mentioned before, includes a guarantor and surety. Right, no questions from members. Clause 6. Provisions supplementary to Section 5. It lays out a number of principles. 1. No conduct by or on behalf of the landlord of a tenancy is not to be regarded as waiving a right of the landlord under the tenancy in respect of the tenant's failure to pay rent. Subsection 2, the ending time. That is when a landlord can again take action, and that is scenario A and B, expiry of the protection period, or B, the beginning of the day on which sections 4, 5, 6 ceases to apply, and the landlord by then can take action again. Subsection 3, if the landlord is required to take certain action within a period, then the effect of subsection 3 is that the period is to be extended automatically. Any questions? Now, if we have no other questions, I do think that the clause 7 is rather complex. How about we save it for next time, because it's now 5:41 and I'd like to make this point. Some members just asked this question. We don't have a House committee meeting on the 15th of April. So in other words, if we're able to complete the clause by clause scrutiny on Monday, together with the 2 CSAs, within 1.5 hours on Monday, we'll be able to submit a report to a House committee on Friday, and then the bill can be submitted for resumption of second reading on the 27th. However, if we're unable to complete our work on Monday, meaning that we need an extension, the next available House committee meeting will be the 22nd of April for us to make an oral report. And that would mean the 11th of May, on which the bill can resume its second reading at the Legislative Council meeting. I have no strong view on members' wish to ask questions, but let's bear in mind the timetable we are working on. That's exactly because we have a holiday in between. Thank you, everybody, including electoral members, public officers, and the DOJ representatives. We'll have another meeting on Monday. Thank you.